when you hear that this meeting is being recorded, you can start again, okay?
Very good, very good.
Professor Marcílio, I don't know if you want to start and then give the word for Professor María Infante.
Okay. Mm-hmm.
Recording in progress.
So, good afternoon, good morning to everyone. Welcome back to this session. Welcome, Professor María Teresa Infante Caffi, Judge María Teresa Infante Caffi. So, we have the pleasure today to have the second part of the lesson of Judge Teresa Infante Caffi about the governance of ocean. So let's continue, Professor Infante Caffi, and then we have some room, some space to the questions. Professor Infante Caffi, once again, yes. Thank you, and the floor is yours.
Thank you very much, Professor Franca, and dear friends from Sedin, from all parts of Brazil, and to our dear guests today. I'm going to share my screen. I'm going to continue dealing with the situation of ongoing negotiations and practices regarding natural resources in areas beyond national jurisdiction. I'm going to share maybe this, to start with this. Can you see?
Yes, perfectly.
Yes, perfectly. This is very good. Let me move this to my screen. Very good. You want it like this? Okay. Well, I would like to show a slide that was introduced yesterday just to locate the subject. We have the zones, governance patterns, and the interaction, sometimes implicit, sometimes expressly wanted or sought between different patterns, multilateral conventions and also regimes. And I think the most important question is to have this view that in a space which has been identified and defined as high seas, and the area which is at the bottom of the high seas, there are regimes that are seeking their places. Let us look at the next one. The next one is an invitation to look at what needs an improvement. What are the requirements to improve governance of these areas beyond national jurisdiction? We have a governance system for the seabed mining, which is based on the principle of common heritage of mankind, which is in the hands, which has been attributed to an authority. And the authority has a very important place in international law, but is still developing norms and rules and guidelines. And we have other areas of seeking for better regulations, which is the question of biodiversity, in an area which is intimately related to seabed area, the area with capital letters. What are the issues? Where to find the guiding principles? I think what some authors, some analysts have announced as a systematic evolution of the law of the sea is a very useful tool. We need to look at an evolution of the law of the sea in a systematic way, in a systematic manner. Regulatory and implementation gaps, if there are gaps, can be addressed using agreed principles and mechanisms. This is a very important assertion. I think I'm very positive looking at this trend that it is not a new a new framework. It is a framework that could be built upon existing principles and in combination with new concepts and with the application of existing principles and with a supplementary trend of new principles that could be brought into the full picture. A nice scientific background. Without scientific background, we cannot look at this evolution. We cannot tackle the evolution of the law of the sea. This is an assertion that I have taken from a scientific board, which is the Census of Marine Life and other projects has highlighted the huge impact that human activities have already had on marine biodiversity and the importance which biodiversity at all trophic levels plays in maintaining ocean ecosystem health and functions. So the scientific background brings or takes us, leads us to look at the question not only in terms of the ecosystem that is at stake, but also the interaction with human activities. And because of human activities is that we have to deal with the question of biodiversity. It's not only the intention to promote scientific research, it is also what can we do as human beings with the outcome, the result of that scientific research, not only for conservation, but also for uses, because there are current uses already taking place. Fundamental questions in international law, a summary of what we have already explained. To deal with the subject means that we have to deal with restrictions of the freedoms of the high seas. Restrictions, positive restrictions, because it's not only for the sake of prohibiting, of limiting, of having too many borders for the human activities. It is also a positive side of restrictions in the sense that freedom, in order to exercise certain freedoms, we have to also take into account the future developments, the future of this biodiversity and the future of future human activities that may come up with the years. UNCLOS, the UN Convention of the Law of the Sea, on the Law of the Sea, is a living instrument. It's a living instrument. And there is a need to engage in innovative practice spanning law and governance in order to overcome this highly polarized starting point that took place, that emerged, and was very, very apparent at the beginning of the discussion on areas beyond national jurisdiction. And to look at principles, we're going to look at the principles that are already being discussed in the conference that is taking place in the United Nations. Principles to address possible convergences. That is why I say that restrictions are going to be dealt with. Restrictions are going to be defined in a way that allow for convergences between regulatory gaps and implementation gaps, regulations and implementation. Who are those who are going to be invited to implement the new regulations? Who are those who are going to be invited, who are going to be entitled to regulate? The protection of marine biodiversity will have to take into account problems of access and problems of benefits sharing. It is not only the protection of marine biodiversity as a denial of the possibility of having access, as prohibiting access, as to some extent having an effect only on the negative and abstentionist side of activities. We have to strengthen the ability to connect diverse instruments and institutions. It is a multi-faceted problem. We have to strengthen the conservation and sustainable use of marine biodiversity, and to look at applicable customary law principles to construct a regime. It is the construction of a regime, which is the invitation we have received from the international community, organized through the United Nations. So HISIS governance, it's not only about using existing instruments, but also developing and adapting existing tools and adopting new tools to produce changes, to regulate activities, and to render a new regime with a high potential of attracting actors of different with different status actors, in order to have a very effective regime, all encompassing and also very attractive for to prevent tensions and conflicts. This is the goal, and this is the prospect of an international legal binding instrument. An international legal binding instrument means to have an instrument which is not only binding upon a few actors, a few selected states, but also actors and subjects reflecting actors defined on the basis of different interests and trying to overcome contradictions and contradicting views. We know that the status quo was challenged with the question of biodiversity. The status quo is not only the application of Part 11 of the UN Convention. The status quo is not only the application of the freedom of the HISIS principles. It is the status quo is challenged because we need something more to have a more comprehensive regime. And lex lata, what can be found in existing law of the sea, but lege ferenda is something we have to build on. This is a very important, I think, starting point to look at this. This is the issue that was sent to the UN General Assembly. We have to go beyond lex lata. So, I must say that the international community, reflecting this diverse participation or participating subjects, concluded that neither UNCLOS nor the Convention on Biodiversity provided a unique and specific legal regime for commercially oriented activities related to marine genetic resources in areas beyond national jurisdiction. This is an assertion with a very strong political background. We have lex lata, but we cannot operate only on the basis of existing rules. We have to go beyond that, not to derogate from, but to supplement, to enrich, and to introduce general principles that are already being assessed from environmental law and also from the law applicable to international or the law what we call international economic law. I mean, that is the question of intellectual property and related issues. So we need some lege ferenda horizon. We need some lege ferenda concept in order to remind that views of states that have diverged should be converging into a set of coherent regulations and conditions on access. That is the question. Access and benefit sharing. Those are the leading ideas when we look at this, look at the search of a new model. Let us look at underlying political views. Always having this reference point. We have the legal background. We say that UNCLOS is important. Other conventions are very important, and UNCLOS is the most important framework to take into account. But at the same time, we have other views that have been influencing the debate, the political and legal debate. developing countries argued in favor of a common heritage regime to create what they called was a level playing field between the haves and the have-nots. So countries that manage, that regulate, have a regulatory power, implementing power, to have access to biodiversity and to obtain benefits from biodiversity studies. So some developing countries, many developing countries, were in favor of an equitable distribution of the benefits arising out of the utilization of these resources, which was a very justified view, and not only starting point, but also the way to proceed. So they wanted to have a benefit sharing mechanism in order to render vivid a principle of common resources. But some developed countries expressed different views, still express different views. We can have an access and benefit sharing mechanism without having a common heritage of mankind approach. How to do that? We don't need a benefit sharing regime related to marine genetic resources because we can have benefits, we can produce benefits through existing regulated practices embedded in WTO and intellectual property mechanisms. So we can operate in a world that respects the freedom of marine scientific research, that respects the possibility of having free access for everybody, and the benefits for humanity will accrue from worldwide availability of scientific knowledge. So rendering the scientific knowledge available to everybody. And the products of that scientific knowledge derived from the marine genetic research will contribute to public health, will contribute in an affordable way, and could not be impeded by a new benefit sharing regime. So this is political discussion. We want to have access to benefits, so we need a regime, developing countries say, and some developed countries say we don't need a new regime because what we already have is sufficient. We can provide benefits for everybody through a very comprehensive and a very active scientific research regime as it exists today, where freedom of access is guaranteed. This is something that was debated politically, but politically also the result was a different one. So a majority was assessed that there was we were facing the absence of a global instrument regulating the establishment and monitoring of areas beyond national jurisdiction. We need a comprehensive environmental impact assessment, and there was a lack of coordination among different institutions and regulatory bodies that were already in place. You remember fishing management organization. We also remember the biodiversity convention regulations and so on. And the starting point to look at the picture in a very objective manner. We have an area where there is no sovereignty. What we have is free access by certain subjects, certain states, certain operators, flying the flag of states, private operators. We have a fragmentation of regimes. We needed, developing countries said, we need something which is more. We need a set of norms, accepted by the international community with very sound decision-making procedures. We don't need a very cumbersome organization, but we need an agreement to add obligations for states. For example, area-based management tools that are respected by everybody. We need to have tools to identify areas to be protected with management tools. We need to agree on standards for environmental impact assessment. So accessing is not maybe free, but accessing should be subject to certain standards and regulations. We need a regime. So from 2004 onwards, there were discussions, very harsh discussions within the premises of the International Civil Authority, and then we sent the subject to be dealt with within the United Nations. Since 2011, marine genetic resources of areas beyond national jurisdictions have been considered as part of a package. So issues of conservation, in particular area-based management tools, including marine protected areas, tied to progress on issues related to marine genetic resources, including questions of benefit sharing, capacity building, and the transfer of marine technology. So this package was part of the deal within the United Nations. And this is the starting point of a new approach toward this matter. Rio +20, a momentum in 2015. In 2015, a sort of working group produced certain elements, made substantive recommendations to the General Assembly on the elements to be embodied in a draft text of such an instrument, and the need to overcome views divided between lex lata and legiferenda. Why don't we work and we seek for possibilities to overcome this gap between lex lata and legiferenda? We always bear in mind that there are divergences in the views of states on whether there should be new regulations and conditions on access to these genetic resources. That is, sorry, how can we go back? No, it is okay. So this 2015 date produced a momentum, or was producing a momentum, where there was an agreement on a new legal or institutional mechanism. We have to take into account long and complex chain of discovery, wherein there is often no clear delineation between pure marine scientific research and bioprospecting. So to look at the chain of activities, a chain from discovery to bioprospecting. And bioprospecting is aimed at looking at commercial activities. I mean the question of production, the question of industrialization, the question of utility for uses, not only for the sake of scientific research. So this is the challenge that started in 2015. How can a new international legally binding instrument ensure enforcement and benefit sharing provisions? That is a challenge we have in hands. For 6 years, states have been working on this and trying to strike a balance between the pure scientific research, freedom of access, and then the question of benefits accrued to all. Benefits accrued to all. This will be a lex specialis within the framework of the law of the sea. We have to consolidate existing legal principles, and we also have to develop new legislation within the framework of UNCLOS, but taking into account this chain from discovery to bioprospecting. Bioprospecting is not only a very relevant concept, but it is also the outcome of many researches that are taking place all over the world, including in Antarctica, including in the Arctic, but Antarctica is subject to special regime, so there is an interrelationship between what we're discussing here and what is going on in Antarctica, where bioprospecting is already taking place, regulated only by international law, the Convention on Biodiversity, and national legislation and decisions. So, lex specialis and consolidation or consolidation of existing legal principles and rules. This is something for research. There is a nice, fine bibliography on this with many studies, some of them confirming repeating previous studies. What we have to look at is what is going on within the UN and what are the highlights of the negotiations and what are the issues that are to some extent structuring a new legally binding instrument and a new regime. The central role of the UN Convention has not been derogated, so that is the basis. The preparatory committee has highlighted certain needs in the negotiation, needs as goals or as structuring ideas, what we could call building blocks of a new convention. It is the need to enhance cooperation and coordination. That is something which is granted, that is done. Recognition of the need for the comprehensive global regime to better address the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. What does it mean to have a comprehensive global regime to better address the conservation and sustainable use? That we have to take into account that it is not only about conservation as a passive to strike a regime which is based on non-activities in the areas. It is with activities in the areas, because sustainable use of marine biological diversity means that there will be developments in the area. By whom? Well, we have laboratories, we have scientific research institutions, we also have states conducting very advanced research. We may have agencies, companies, and so on. So the interaction will be very rich because those entities and laboratories and companies are based on the territory of certain states. So this is the complexity of the new regime. And also the recognition of another need. We have to assist developing countries. In particular, and then there is a glossary or a kind of identification of special interests, geographically disadvantaged states, least developed countries, landlocked developing countries, small island developing countries, which is a very active group for negotiations, as well as coastal African states, in order to allow them to participate effectively in the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. So this is a very strong political element. Full participation, not only in the negotiation of the instrument, but also in the development of its implementation, development of activities, but also having the possibility to participate in the decision-making process and in the benefit sharing of the outcome of the implementation of the regime. Basis of the negotiation summary will have to address which are the topics, the main index of this negotiation. Marine biological diversity for areas beyond, with a focus on marine genetic resources. So within the full body of biological diversity, there is the question of marine genetic resources. So marine genetic resources is, we mean those resources that contain heredity. It is the functional unit of heredity. It is la herencia genética. The focus on marine genetic resources. Questions on the sharing of benefits. Measures such as area-based management tools, including marine protected areas, which is a very powerful concept. Environmental impact assessment, and capacity building and the transfer of marine technology. Capacity building is very important to match the interest of those states with special needs and special situations, landlocked states, small island developing countries, and so on. The regime will have to take into account the relationship with the convention, with the UN Convention, and other instruments. What is the importance of this? The importance of this is a twofold, if I may say. One is a non-derogation clause. I mean, the new regime is not meant to be derogatory of existing instruments and the UN Convention. Sovereign rights, jurisdictions granted to coastal states and other states, so the powers of states through different avenues, non-derogation, and not to undermine the validity and effectiveness of existing frameworks, bodies, and instruments, not to undermine. The number of instruments could be huge. There is no identification or specification of which are the instruments not to be undermined, but we can think about different regulatory bodies, from WTO to WIPO, Intellectual Property Organization, to the Antarctic Treaty, to IMO conventions dealing with maritime security and anti-pollution norms, and so on. So this is an important question. And now we go to the structure of the current negotiations. 2015, the identification of the areas we have mentioned and we have referred to the preparation of the negotiations, and now the current negotiations. The current negotiations, in a very formal way, are being reflected in the draft text. In the draft text, which is still being worked on, which is still being dealt with, and which is part of the ongoing process of exchange of views and positions. Different parts. First, the question of marine genetic resources and questions on the sharing of benefits. Second, or part 3, measures such as area-based management tools, including marine protected areas, financial resources, and mechanisms. Another part is environmental impact assessment, how to deal with that, where to submit the environmental impact assessment, when to proceed with a full and comprehensive environmental impact assessment procedure. Capacity building and transfer of marine technology, institutional arrangements, financial resources, implementation and compliance, which affects states and third states because activities will be conducted under permits, but at the same time you have to be accountable to others. Says dispute settlement, which is not an easy matter to deal with, and then the question of non-parties to the agreement. Non-parties is a very delicate issue because even if the negotiations will seek to attract the participation of a full majority, very representative of the international community, it may happen that some states remain apart. Let us go to the definition of access. According to current negotiations, but you see brackets, so nothing is agreed at the moment. Everything is being discussed and analyzed. It is access means access to marine genetic resources. So those are the resources that are going to be regulated by the new instrument. It is the collection of marine genetic resources. And now we have to discuss in situ, I mean located there, ex situ, in areas or in laboratories or in systems where they're kept for future research, and in silico. Silico is the reproduction with digital sequence information. So it is a third stage in the phase of collection and scientific marine research, genetic sequence data. Are we going to cover all the series of activities, scientific research through the concept of access? This is a part of the debate. And areas beyond national jurisdiction mean HISIS areas, and the area with capital letter, which is the area where seabed mining may take place. Marine genetic material means any material of marine plant, animal, microbial, or other origin containing functional units of heredity. That is the central definition of marine genetic material. That is what we're going to collect, and that is what we accept, we agree to regulate through a new regime, a common regime. And then we go through different sub-definitions that are alternatives. And the question of potential value, it's alternative number 2, marine genetic material of actual or potential value, is important because potential value is one element that is being taken into account by these norms which are part of the WTO regime. What is patentable? Patents are looking at this potential value. What is the value for medicine, for pharmaceuticals, for I don't know, maybe recreation of nature, I don't know. Well, the general objective of the regime, which is the objective of this regime in general, it is to ensure conservation and sustainable use of marine biological diversity. When we look at conservation and sustainable use as terms, we're thinking of this question of sustainable development, the question of the future, to preserve resources for future generations, conditions of access, conditions of accessibility. It is the need to have agreements in order to preserve the existence and the potentialities of these resources for the future. This is very important because this is the starting point to produce or to generate agreements that are not only agreements denying the possibility of use, but also allowing for use, but in a sustainable manner. And the effectiveness of the provisions in order to have an implementation that ensures the sustainability. This is very important. So we need international cooperation and coordination. This is a definition that is accepted by Latin American countries, by South Africa, the Republic of Korea, and it is agreed by the International Union of Conservation of Nature. And a very famous and important provision, which is not totally and finally agreed. It is not to undermine existing agreements and not to undermine the law of the sea as it exists. Relevant legal instruments will have to be preserved. What are the risks? Well, there is one risk that the definitions and the objectives could be perceived as undermining the rights and jurisdiction of coastal states. This is an area to be preserved. The other area to be preserved is other instruments that are applicable in the high seas or that are applicable to marine biodiversity. How to preserve that? Well, there has to be a very strong clause subject to the possibility of a judicial control through dispute settlement mechanisms. The legal status of non-parties to the convention, to the UN Convention on the Law of the Sea, is also part of the deal. Here we have a problem which is a legal problem and a political problem. You know that some states like Turkey, Colombia, and other states are not party to the UN Convention on the Law of the Sea. And they would like to have an explicit clause preserving their position as third parties to UNCLOS. The problem is that there are some provisions in UNCLOS that may be seen as customary law. So the question is very cumbersome sometimes, because there is political position, there is a legal position, and the issue of non-application to them of the UN Convention on the Law of the Sea should not weaken the possibility to have a regime in which certain principles of the UN Convention on the Law of the Sea are applicable to the high seas and to these activities conducted in the high seas in areas beyond national jurisdiction. This is not a clause that is fully settled, and maybe it may be subject to additions and to clarifications. But it is important to look at the question of the continental shelf within and beyond 200 miles and the economic zone. Because for the continental shelf extended beyond 200 nautical miles, there is the question of the column of water, which is high seas and where there is biodiversity, but that could be related, that could be intimately related to the bottom, the seafloor, and the resources existing there, and belonging to the extended continental shelf. I mean sedentary species and so on, related to sedentary species. Now we go to principles. This is a very important piece because this is another view. You have the formalistic view of existing instruments that may be also applicable to the areas. But here we have principles, and these principles come from or are based on existing instruments and customary law. Those existing instruments include such principles as the principle of non-regression, not to go back to a lex lata that produced less effects, that were less ambitious as compared to this new lege ferenda, which will become lex lata. The principle of polluter pays principle. Polluter pays. What does it mean? It is to internalize the environmental costs and to use economic instruments to render those subjects who are polluting, to render activities conducted by those subjects more costly in order to balance the burden that states behaving in a sustainable manner with those who are not conducting activities in a sustainable manner. So the polluter should bear the cost of pollution. They have to have due regard to the public interests and without distorting the international trade and investment. So the question of balancing the way they are conducting activities in order to have a fair and transparent competition in international trade and investment. This is important, and we have to use all sorts of mechanisms in order to avoid and to prevent the generalization of polluting activities being conducted in the high seas, competing with no polluting activities of states taking care of all sorts of precautions. This is very important because we see the question of the consequences of illegal fisheries in another area, where you have competitors unregulated with subjects or with entities conducting fishing activities in a highly regulated system, or in accordance with highly regulated mechanisms. The principle of common heritage of mankind. This is something to clarify. The principle of common heritage of mankind is already applicable to minerals in the area. It is not an expansion of the idea to have a common heritage applicable to other resources. It could have been, or it may be in the future. We don't know, because what we are doing here is to bring more substance and more substantive requirements to access and exploitation of resources that are common resources. And the only difference is they are not creating a system of access that will be through an international organization. But that access will be regulated. It is not through an organization like for minerals, but it is through states, but meeting certain standards and very strict regulations. Equity, question of landlocked states, small island states, and here a very important question, the precautionary principle or approach. You know that there is a distinction that is prone by different political thoughts and so on, and economic thoughts, that the precautionary principle is not a principle, it is an approach. I must say that the precautionary principle was enunciated by the International Tribunal for the Law of the Sea in 2011 with respect to the conditions under which operators are operating in the marine environment in the area. So it doesn't mean if it is a principle, it doesn't mean there is a lot of difference, approach or principle. The precaution is the precautions not to subvert, not to revert the burden of proof. It is to take all reasonable means or reasonable measures to avoid certain impacts and damage, especially damage, when you don't have enough scientific research. There are doubts about the management of scientific knowledge or access to scientific knowledge in order to assess which are the consequences of your own activities. So the precautionary principle is very important, it's of paramount importance in this activity. When you are not sure what are the scientific elements that should apply to a certain activity, there's not enough knowledge. The ecosystem approach, which is the question of the combination of what you are doing for the whole area, a contextual approach towards the ecosystem, integrated approach also, an approach that builds ecosystem resilience to the adverse effects of climate change and ocean acidification, and restores ecosystem integrity. So an approach which integrates the concepts that are being developed in areas such as climate change studies, fighting against acidification, and the concept that you have to restore the ecosystem integrity as much as possible. This is the question of due regard to other areas. This list of principles is supplemented by the use of the best available scientific information, the non-transfer of damages and hazards from one area to the other, and so on. Let me tell you that there is a debate about the hierarchy. Are those principles only approaches, or are they principles? A principle is a definition of something which is basic. An approach is something which is more to be an active development of a procedure, so it's more procedural. Is there a hierarchy? This is something to be debated. There are some observations. Some groups and states would like to delete some of these principles or approaches. Some states would like to have guidelines, not a list of principles. I bet that there will be principles in the new regime. I bet that will be the solution, because that is something which is important. So a hierarchy maybe will not exist as a hierarchy 1, 2, 3 to be seen as different categories, maybe principles playing together or interrelated, but very important question to think about it. We need principles, we need principles. International cooperation is important. International cooperation not only as a question of a general goal, but also integrating the existing instruments, and also promoting scientific research in a way that integrates different views and different subjects. Something which is important, fisheries bodies. For Latin American states and for other states, fishing activities and fisheries bodies should be preserved, so should not be part of the new regime, should be taken into account and not be undermined. So species that are collected under the concept of fishing activities and fisheries should not be derogated. The sharing of benefits, mandatory or voluntary. Will benefits include monetary benefits? How can a new instrument ensure enforcement of benefit sharing provisions? To strike a balance between existing benefits and future benefits, that is a very difficult question to solve. Are benefits being considered only through capacity building and transfer of technology, or also will include some monetary benefits? Well, let us look at the development of the regime. This is an area in which I confess I have no specific knowledge as to what is the best model to follow, which is the pattern to follow. There will be monetary and non-monetary benefits, but monetary benefit will not be money being allocated, will be, for example, to establish a fund that could fund other activities, to provide basis for some international payments, which are based on commercial profits, or to provide benefits for research, to develop traceability mechanisms that are subject to, that are accessible by developing countries, to have traceability tools in their own countries, to know where those resources were caught, from discovery to transformation to commercial activities and so on. We have to promote, the idea is to promote the generation of knowledge and technological innovation that is accessible, that is open to be used by other subjects. So there are different alternatives. You see A, B, C, D alternatives, and with different views. It's not only to assist to collect, but also to assist to conduct research and to be able to utilize the marine genetic resources beyond natural jurisdiction by all states that are interested in the subject. So less barriers, more openness, but respecting, of course, the creation of knowledge through intellectual property. The European Union would like to add a provision saying that the regime will have to promote the scientific understanding of marine genetic resources in areas of beyond national jurisdiction as a fundamental contribution to the implementation of the agreement for the conservation, the promotion of scientific research, so more capacity building, and so on. Let me see here activities with respect. I'm going to go to this tool. You have access, we have benefit sharing, we'll have to look at a mechanism, area-based approach and marine areas. This is something where there is a lot of consensus in the sense that one tool, in order to implement these principles, or the principles I have already referred to, the precautionary principle, the ecosystem approach, science-based approach, and transparency, through area-based management tools. So to declare a specific area to be managed, that is, it is going to be managed with certain tools, will make it easier to introduce the effective application of the precautionary approach, the ecosystem approach, and science-based approach, and through transparent means. This is a very important instrument that will have to be implemented in this new regime. Let us look at the next one, access to traditional knowledge. The preoccupation about access to traditional knowledge of indigenous people and local communities is also part of the deal, although it will not be the mainstream, in the sense that all genetic resources will produce this problem, this question, will call for this issue, but this is a question which is of political importance now. Fair and equitable sharing of benefits. You see that there is only brackets. That is a very difficult question. What are the benefits for? For everybody, or only for certain categories of states? Special considerations of developing countries, and so on. Well, we will see the continuation. And let me see, because I want to show you a question of intellectual property. Intellectual property is part of the deal, because we have access to discovery, access to collection, then you have in situ, you have ex situ, you have the question of ex silico, I mean the sequence of gene, once you dominate the sequence of the genes, and so on, gene sequence, and so on. Well, the options are to have no reference to intellectual property, no text option. This is a doctrinal distinction. These are not categories that are being discussed as such in the conference, but that are a theoretical present. No text. Second option, to ameliorate existing frameworks. Which are the existing frameworks? WTO, WIPO, Intellectual Property Conventions. What it is called, it defined a tinkering option, the tinker, operating with existing tools. The option that is precluding intellectual property. So we preclude the operation of existing frameworks, no existing frameworks. So there will be no intellectual property protection. Nothing will be covered by this. It will be open access intellectual creativity, or the consideration of new rules for intellectual property. So this is something that is being discussed by specialists, and I must say that the trend is towards the inclusion of intellectual property rules, and to have to use or to get inspiration from existing intellectual property regimes and instruments, and to make them operate and function in a way that they are supportive of the agreement. That is important. So marine genetic resources collected in accordance with the agreement shall be subject to existing agreements, or they will not be subject to patents except where such resources are modified by human intervention, resulting in a product capable of industrial application. The alternative is genetic resources are not subject to intellectual property rights. This is something we have to assert. This is a basic ground for the negotiations. Genetic resources that are appropriated by certain subjects should not be protected by intellectual property. What is going to be protected by intellectual property is not a sample. It is the transformation, the introduction of knowledge in order to create new materials. That is going to be protected. That is what is called bioprospecting. So in bioprospecting, we can introduce intellectual property rights, but not in the genetic resources as an object of scientific research. Let me see. This is a question. There is a thin line separating discovery from invention. Genes cannot be patented per se, but there is a list of potential applications that may be developed. So this, for specialists, this is a very, very important question. So the governance issues for access and benefit sharing is absolutely essential in order to distinguish between scientific research, discovery, and application, and so on. If not, there will be no sharing of benefits. And the third question is gene patenting and issues. The ability to control the chain of procedures. Well, this is a very important issue. This is the core issue of the negotiating package and the issue of patenting law and so on. Let us move to another question before leaving, because I don't want to use all the time before questions, and to move to monitoring screening. The question of screening will be essential in the regime, which is the ability to determine whether an environmental impact assessment will be required in respect of a planned activity under the jurisdiction of a state or control. So environmental impact assessment and that procedural matter and that the area-based management tool are part of the package of the deal. What is screening? It is you have to submit your activity, which is collecting genes, in areas beyond national jurisdiction, you have to submit that to an environmental impact assessment procedure, the conditions of which will have to be negotiated. That is absolutely important. So you have to submit to initial screening of activities. For what? Because you have to assess if your activities will produce an impact that will be a minimum impact, transitory one, or a more large one, and permanent and non-reversible could be. So resilience of the activities is very important. Consider cumulative impacts. Are there going to be cumulative impacts? So the consideration of that will have to be regulated. Obligation to conduct environmental impact assessment. And then we have the brackets as far as practicable, a control on the marine environment, or only on the resources. We will include the marine environment, I'm sure of that, and so on. And the plan activity, you have to plan your activities. And when they may cause substantial pollution, harmful changes, minor or transitory effects, individually or collectively, you are going to conduct activities individually or collectively. What are the potential effects of your activities, and so on. So the thresholds will have to be very clear to take into account transboundary impacts also of your activities. So the question is very, very important. Many issues, capacity building and transfer of marine technology will be part also of the deal. Maybe if you invite other states to look at your environmental impact assessment, you will be enabling other states to understand what it is at stake, not only when you want to avoid harmful effects, but who is going to determine when you need a full and comprehensive impact assessment. That is something to be discussed. The question of small island states, and let me move to the final part, which is the possibility to have a clearinghouse mechanism, which is a clearinghouse mechanism is a mechanism or a platform where you provide access to knowledge you have collected in order to be used, in order to render the knowledge accessible, and also to enable other practitioners, for example, academics, laboratories, other states. A clearinghouse mechanism may be very functional to the operation of a new regime. That is something Latin American countries are supporting and trying to introduce elements to become components of this platform in a useful way, in order to match demand with supply, promote cooperation, and facilitate the exchange of information. Some conventions have already established clearinghouse mechanisms that are very, very interesting, including the International Maritime Organization, the UNESCO, cultural instruments, and so on. Let me move. The question of compliance with this, I'm going to finish. This side, this part, implementation and compliance. We have a regime which will be innovative. This is a legislation which is based on existing norms, but also on an evolution of existing norms and new norms. But we always find a stage in which we have to ask ourselves, who is going to implement this? Who is going to be bound by compliance norms? First of all, states parties. Then some international organizations, which are competent in the seas, and international organizations which not only are competent, which are already working in the seas. For example, International Civil Authority, for example, International Maritime Organization. But first and foremost, states parties shall take the necessary legislative, administrative, or policy measures as appropriate to ensure the implementation of this agreement. This is the basic rule. Why is it important? Because states parties will have to adopt legislation to not only to develop certain principles, but also to adapt a new regime to the existing domestic institutions, to entrust institutions, to create institutions for monitoring, for environmental impact assessment procedures, for controlling, for issuing of permits, and so on. And then between brackets, we have other concepts that could be part of this compliance. For example, monitoring in a format to be determined, reporting to the conference. You know that in certain environmental conventions and human rights conventions, we have the reporting activities, national reports, national periodical reports. Maybe we'll have to introduce this tool in this new convention. And the Conference of State Parties, of the parties, shall consider and adopt procedures and institutional mechanisms. This is something to be discussed because it has not been agreed yet by states. Effective mechanism and dispute settlement, because for dispute settlement, when you have different operators, is it enough to consider state-to-state dispute settlement mechanisms, or also the dispute settlement mechanisms able to deal with questions of intellectual property, data collection, access to platforms, and so on? We will discuss further this issue. And then there is the situation of states that are not party to UNCLOS. El Salvador, for example, that is very active in the negotiations, or Colombia, two Latin American countries which are very active in the negotiations but that are not party to this, are party in the negotiation but not party to UNCLOS. And here a table that summarizes to some extent this change or stages of activities. We have access, the first stage, access, which is collection, biotech research and development, which is applied marine scientific research, extracting components, for example, identifying and isolating potential biotech products. So biotechnology, which could be aiming at commercial activities or aiming at pure enhancement of knowledge. Biotech research and development in the sense of producing and testing and producing goods for business. So looking at the business activity, commercialization, bioprospecting, in the sense of bioprospecting, and pure commercialization, where you have what they call, I have seen that in vaccines, a trial stage, when you start from scientific research and then you go through different trial segments until you put a product in the market. And then you have the monetary benefits. If you have monetary benefits, for example, in 20 years, in a 20-year timeline, are you going to tax that, to apply to that monetary benefit a taxation which will be international? That would be something interesting to look at. I will not be alive at the moment, but maybe we will be looking at a moment in which there will be an international profit from this, like we expect to have an international profit from minerals from the seabed area. 2 words about minerals, and now, and we will stop. We looked at the beginning of this lecture at the situation of an existing regime. An existing regime, the test of which could be perceived, could be assessed in the prospecting exploration phase. And now we have to go to the exploitation phase if it is going to take place, in order to determine if we're going to go through or to pass the border between exploration and advance towards exploitation through contracts and a very complex legal system which has already been established. Who are the commercial operators? And there is an R that is lacking. Obligations and liability of sponsoring state. The regime operates through sponsoring states. We believe that this concept could be applicable to the high seas biodiversity. Could be applicable or may be applicable. Obligation and liability of sponsoring states. Who are sponsoring states? The states that authorize activities to be conducted in respect of minerals. In accordance with the convention, there can be natural and juridical persons, nationals of state party or effectively controlled by it or its nationals. So the question of effectiveness in the control of a state over a national that is interested in exploiting minerals is important. That effectiveness can be legally assessed and judicially determined also or controlled. The effectiveness translates into a legal term, which is the sponsorship, sponsored by a state. And it was said in 2011 that there are certain obligations of sponsoring states. It is a responsibility to ensure and direct obligations under the law of the Sea Convention and other relevant instruments for the operator to comply with its own obligations. The due diligence obligation, due diligence responsibility by state parties sponsoring activities. The result is that the sponsor contractor will be able to comply with the obligations to conduct activities in a sustainable manner. It is an obligation upon the state of conduct, not an obligation of result. It means that the operator will have to respond for its own conduct and the consequences of its own conduct. To implement direct obligations, to adopt legislation, to have instruments, to control, etc. It's direct obligations of the sponsoring state. Obligation of the state to assist the authority, to apply a precautionary approach, that is the precaution, so to avoid activities that are not fully assessed and not being damaging, the best environmental practices to guarantee in the event of an emergency order by the Authority for Protection of Marine Environment, to provide guarantees in the event of an emergency, and to be available of recourse for compensation, prompt and adequate in case there is a lack of compliance with this obligation of conduct. The current situation is very interesting. There are a number of contractors, 29 for 31 contracts in total, coming from the Pacific, the Atlantic, and the Indian Ocean, sponsored by state parties. Those contractors are private, public companies, and consortia. There is even a contractor that is Brazilian, Companhia de Pesquisa de Recursos Minerais, which is a state-owned contractor, public company or public contractor of Brazil. This is very interesting because there are different experiences. public and private. So you have an actual interest in mining, and they're waiting for the approval of the mining code in order to go beyond exploration. Nauru has been pushing for this and just requested a plan of work in 2 years. So states will have to decide, because the rules of the convention are a bit automatic in the sense of launching a new phase if a state requests the anticipation of a plan of contract when the mining code has not been fully completed. And we will see what happens in the next months. Here you have a picture showing the situation in the world of areas of massive sulfides in mid-ocean ridges. And you see areas which are very, very interesting here. You see areas here, we see areas here and here of massive sulfides in the areas, well, in the Pacific, in the Western Pacific. We have also in the mid-Atlantic, if I may say. France and Russia are there. Korea, China are interesting in here. And well, we're looking for developments in the area of exploitation. Codes for prospecting and exploration for polymetallic nodules, for polymetallic sulfides, and cobalt-rich ferromanganese crusts have been adopted, and obligation of contracts and so on. And with this, we will finish, because we're looking at the famous Clarion-Clipperton area, which is subject to many prospecting and exploration contracts. Several of them, most of the contractors are looking at this area, which is a rich area of the area with capital A. And what is important now? Why not to go immediately towards exploitation? Because of the environmental concerns and because of the biodiversity discussion. Some states would like to be assured that there will be no damaging consequences for biodiversity and for the environment. And second, the concern expressed by land-based producers that some productions in the seabed, without finishing a full-fledged code, including requirements that are similar or equivalent to those applicable in land-based production sectors, will create an unbalanced situation between seabed mining and land-based mining. So this is a very harsh political scenario. I think states will be able to overcome those concerns and to work together for the future. With this, I end my lecture. Maybe I spoke too much. Professor Marcílio, I'm absolutely open to receive questions. We can answer at least 2 questions, maybe.
Yes, could be.
Very good.
Thank you very much, Professor Judge Maria Teresa Infante Caffi. It was a wonderful presentation. I expected nothing different from that. Thank you very much. It was wonderful. Like I mentioned yesterday, I think only you could offer us such an interesting presentation, thanks to your experience as scholar, diplomat, judge. So thank you very much. So I think we have some room for questions. I don't know if we have some questions. I have a personal doubt. Yes, I want to ask Professor Judge Maria Teresa what could be the impacts of COVID-19 pandemic in the oceans regime. what are your impressions, in particularly about the impact of COVID in the international law of the sea and in the work of the ITLOS in the Tribunal of the Sea? What do you have to say to us?
Let me tell you. Let me say the following. I think it is the law of the sea regime as such, based on the UN Convention and other conventions and working institutions, has been very much present in certain situations in which COVID has put certain stress or tensions regarding the normal conduction of certain activities. I can see two areas in which COVID has impacted it a lot. One is maritime transportation and the question of seafarers, because navigation that is in the hands of human beings has been very much impacted by measures adopted by certain states to close ports, to interrupt communications and transportation, and to provide humanitarian assistance or humanitarian support to those persons and human activities. So not indirectly, but a secondary impact of COVID has been the question of the interruption of normal lanes of communication in the world that has had a tremendous impact on people who have get stuck, stranded in certain ports and on board or in certain countries without access to their national countries and without access to normal assistance. This has been a human rights, if I may say, impact, which has been very much assessed, and there have been discussions within the IMO, under IMO, how to deal with this, because there is a state responsibility, but also agents and lines, ship lines, and the whole system of service providers. That is very important. COVID has had an impact. Second, the question of migration and COVID. Maritime migration and COVID could be seen as only a minority issue, a minor issue, an issue that only affects certain areas and regions. Maybe it is larger than that, because of COVID, transportation is subject to very strict regulations. But at the same time, certain states do not allow maritime migrants or migrants using maritime lines to approach certain ports. Worsen with the COVID situation. So the health crisis has been also targeting those people who do not have the possibility to be assisted, to be rescued, or to be admitted in certain ports. So I think COVID has had that element, a very important element.
Yes,
I have not seen piracy interrupting the transportation of vaccines, because normally vaccines go by planes, by airlines. But there are some other activities interrupting the communication of vaccines, because they could be to some extent subject to measures of what is the name taken during the transportation cycle. But I think the law of the sea should be very aware of the humanitarian components of the application of the law of the sea. The humanitarian aspect means that when you are dealing, this is something that the Law of the Sea Tribunal has dealt with in a very in a complementary way in certain cases when you have the rest of a vessel, but the vessel is arrested together with the crew. And there are some human rights effects on the rest of the vessel because the crew is stranded, is not allowed to move out from a country. So I think this is a very important, your questions brings a very important chapter of current international law. So cooperation is not only cooperation to facilitate access to developing countries. Cooperation is something which is more political.
Mm-hmm. Yes.
Open to discuss problems that need to apply existing rules, but also to open the possibility to have other rules. And that is the case in these pandemic times.
Okay, so I think once we are approaching our time, I think yes. I want just to leave some time to you to your final remarks. I know this is your final conference today, Professor yes. María Teresa. So you have some free time just to your final remark.
My final remarks will be the following. We have exposed, we have presented a subject that is part of the current agenda of the law of the sea. This law of the sea has been illuminated by the jurisprudence of the international tribunals, ITLOS, ICJ, arbitral tribunals. But in the area in which we have been focused during the last 2 days, it is the responsibility of states to adopt new rules to make this law of the sea evolve in a sound manner, in a comprehensive manner, and to keep the momentum of the interest of states from different positions and with different positions and different regions and geographical locations working together. In some areas, we have difficulties. We have seen this question of the creation of knowledge based on the knowledge of the genes, the heredity, and the application of intellectual property rules, which are part of these haves and have-nots, if we understand the word in that dimension. But at the same time, we can create new norms in order to render possible the access, not only accessing for collection, but also accessing for knowledge. In seabed mining, we are in a different stage, but it is also a challenge for the international community. Access for the raw materials, but also access for knowledge, and the absolutely non-derogable question of the application of two principles. It is the precautionary principle and also the obligation to conduct an environmental impact assessment and to be subject to screening. I think this is my lesson of today. I would like to continue being in touch with you. It has been a real honor to be present today before you. Thank you very much.
Thank you very much. It was our pleasure, Professor. It was our
yes.
Be sure. Thank you very much. Once again, thank you very much for sending from Professor Leonardo Nemer. It was a great pleasure.
Who could be present from that nice, very nice city and region.
Yes. I hope next time in presence in Belo Horizonte.
Oh, that would be nice. That would be nice. Very nice.
Yes. Good. Okay, thank you very much. So see you next time, next year.
Thank you very much. I'm sorry because I don't speak Portuguese. I can understand it, but I should do more on that direction.
Boa tarde a todos. Adeus.
Thank you, Professor.
Thank you, Professor.
Leonardo. Goodbye.